Today is fixed for the hearing for habeas corpus application of K Selvach, and we are ready for the hearing today, and we have prepared to proceed with the matter. But early in the morning, before the court started, the federal counsel asked and approached us and asked that they would want to ask for postponement for the hearing today, and we objected to this adjournment application by the federal counsel on the ground that they have not written to us, and they have not written to us and to state reasons for the application for adjournment today. And we have actually served the notice usul on the 10th of November 2010, and also the sealed copy of the notice usul, and together with the affidavit. The notice usul for the application for habeas corpus.
Notice usul.
Yes, served on the 23rd of November 2010.
23rd.
Yes. Okay, first one is the unsealed one, because once you file your application, you have to file the unsealed copy to the court to give notification that you are filing this application, and we have served it on the 10th of November 2010, and later when we extracted the sealed copy of the notice usul for the application for habeas corpus, we served it on the 23rd. And because of the urgency of the matter and the circumstances surrounding the case, we pray to the court that this matter is going to be heard today. However, the federal counsel is asking for a postponement, saying that they have yet to come back with the affidavit in reply of our affidavit in support of the application. And the judge actually granted until 6 for the hearing of their application for extension of time to file the 6 January next week, for the extension of time for them to file their reply to our affidavit in support.
The notice, the application to the wrong person?
No, we served it on the AG chambers because under the Government Proceeding Act, it's clearly stated that all documents must be served on the AG. So we have served it on the right party, and we are quite unsure why the judge said that we served it on the wrong person, because we've got the acknowledgement by the AG chambers that they have received the documents that we have served on them.
Under the what act? Can you repeat?
The Government
Proceeding
Act 1956.
1956.
Yes. Documents must be served on the AG's chambers. And we have served it on the AG's chambers and acknowledged receipt by the AG's chambers.
So, why is it not counted from the 23rd of December instead from the 26th?
Basically, under the proceeding in criminal courts, this 14 days rule, as you can see in the civil proceeding, do not apply. But however, perhaps it has been the practice of the court to give 14 days and 14 days for parties to have opportunity to reply. But we're seeing that based on the cases that have held in an urgent matter of habeas corpus application, it must be heard immediately. And it's not that we just served the documents on them like one day ago. It was served back on 10th November 2010, and they have knowledge of the fact that we are applying to the court for writ of habeas corpus. They should be ready, and they should come with the documents and proceed accordingly today. That's
So
the
they
position
ask
we
the
are taking.
consumer to reply to the affidavit, and
Pardon?
you said just now they ask for postponement because they need time to
Yeah, they need time to reply to the affidavit that we have served on them.
Only the affidavit?
Yeah, the affidavit, yes. Of service, okay. Basically, in criminal proceeding, affidavit of service is not a requirement, unlike the civil proceedings. Therefore, I believe, letters should be sufficient to show that we have served on the parties, and they have not disputed that we have served on them, and they have acknowledged receipt. So, based on the urgency of the matter, and also the fact that liberty of a person is involved here, and he's been deprived of his liberty, we submit before the court that it should be heard immediately. However, the Peguam Kanan Persekutuan objected to it and asked for another date to actually reply to our affidavit in support. He's currently detained, I believe, in Bukit Jalil Detention Center. Yes. No, not that we know of, because the last time we went to see him was to get his signature, but at that point in time it was very difficult to get him to sign the thing because the police keep changing their stories, and when we went to see him, they brought him to IPKKL. We don't know for what reasons. They're trying to hamper or prevent him from having an effective legal representation, and for him to give effective instructions to us to challenge the detention in court. So we are having that difficulty, and therefore we are asking the court to consider hearing the matter today, because we don't want to prolong it any further, because his liberty is at stake right now, and he's been detained for more than 30 days today, since because he was detained on the 25th October 2010, and today is already 3rd December. Yeah, we are very worried of his condition, and therefore we hope that the court would consider these facts.
When was the last time you saw him?
Pardon?
When was the last time you saw him?
The last time that we saw him was
26.
we filed before 10th, before the filing of the application, I believe around 9 or 8 October.